Welcome to Chapter 2. This chapter we're going to talk about kind of an introduction or a survey of contract law. In Chapter 1, we did an introduction to law generally with just a touch of contract law thrown in the mix. In this chapter, we're focusing on the topic of our course, contract law, but we're kind of doing a look at the entire topic in very, very broad terms. There'll be moments during this presentation I predict that you'll say to yourself, gosh, surely there's more to that topic than what she just said. And you're almost certainly right. I'm just going to be kind of throwing out some ideas, and then we'll spend the rest of the course developing those ideas in much more detail. Most of the slides, or at least many of the slides that I'll be covering, actually have a whole chapter about them as we go forward. So don't feel off-put if you think to yourself, gosh, I don't really feel like I understand this concept very deeply. There would be no reason why you would at this point. We're just kind of helping you make sense of the broad ideas. One of the things I like to do when I'm learning a new topic is I like to get a sense, I call it arranging the furniture. That's not a very technical term for it, but I like to understand the universe that I'm about to visit, and I like to get to know where the main landmarks are. This is where the sofa is, and this is where the end table is, and here is a recliner, and here's a coffee table. And I don't know much about any of these pieces, but I kind of get a sense as to where the sofa is in relation to the coffee table, and the end table, and where the coffee table is in relationship to the end table, and where the coffee table is in relationship to the recliner, and where the recliner is in relationship to the sofa. I don't know much about any of these individually, but I have a sense as to what space they generally occupy. And then once I get a lay of the land, then I can be more detailed about, is this a three-person sofa? Is it leather? Is it fabric? All of those issues I can resolve in more detail, but I want to get an overview. Studies indicate this is a pretty effective way of learning a new topic. Understanding topics in isolation without seeing their connections to the larger topics can ultimately get you kind of off base and maybe not making the right connection. So it's good to have a broad view and then to fill in the details from that point. And anyway, that's what my attempt is going to be during this chapter, to kind of introduce you to those concepts. So I would encourage you as we go forward in this course to, if you're ever swimming and lost and you're not quite sure where your bearings are and where the coast is or where the island is or whatever it is that the landmarks that you're looking for, come back to this chapter, because this is a good grounding point where you can kind of see the big topics and how they interact with each other. Okay, so let's begin. I've kind of already said all this, but let's refresh it a little bit. We're going to be talking about the big concepts of the law. You know, when we look at a picture of the earth, we see big issues. We see the United States, or I guess North America. We see South America. We see the Pacific Ocean. We see the Atlantic Ocean. But we can't really see Plano, Texas, or Frisco, Texas. We can probably figure out about where Texas is, but we can't see details about that area. And so it's just helping us to see the big ideas without getting lost in the details. And that's what we're going to do in this chapter. We'll fill in, trust me, we'll fill in all of those details going forward. So here is a definition of contract. Before I share with you a definition, let me pause and compare a definition with the elements of something. Okay, so imagine that I wanted to make some sugar cookies. And so I'm trying to go to my pantry and see what I have to make sugar cookies. Let's say that I'm not planning on following a recipe. I just kind of have a sense as what I need for sugar cookies. I think to myself, I'm going to need some flour. I'm going to need probably some vanilla. I'm going to want an egg or two. I'm probably going to need to have some butter. And obviously, I'm going to need some sugar, right? So those are some things that I'm pretty darn sure I'm going to need. I'm probably also going to need some kind of leavening agent, probably baking powder, more likely, but it could be baking soda. So those are the ideas that I have. Those are what we call elements or ingredients of sugar cookies and whatever it is that we're trying to make. The essential things we have to make that bigger thing. If I were going to make a molecule of oxygen, I know I need 2 hydrogens and 1 oxygen, H2O. That's the formula for it. If I have too many hydrogens or too many oxygens, it's not going to, in relationship to the other ingredients, not going to make water. It may make something, it may even make something useful, but it's not what I had intended to make. So that's what elements are. A definition is in many senses similar to elements, but it's focused on a different thing. It's not focused on breaking down the constituent parts, it's focused on describing what you have once you have all those constituent parts together. So for example, when I'm talking about the elements of oxygen, I'm going to, the elements of water, I'm going to talk about hydrogen and oxygen. But when I define water, I'm very likely to just talk about things like it's a liquid, that it has 3 states. I guess it is the form of water that's in a liquid format, I guess is what we think of as water, but it can also be steam and it can also be ice. Those are the ideas that I'm going to talk about. I'm not really going to focus on the elements because after all, people knew what water was before they knew about hydrogen and oxygen making water. So there's a distinction between elements and definitions. So I'm going to talk right now about the definition of contract, and then we'll talk about elements, and we'll see there's some significant differences. But there's also some similarities that are important. So when we look at the definition of a contract, we typically think of there being 4 aspects to the definition. What is a contract? Well, it's an agreement. No big surprise there. If people can't reach an agreement, well, they don't have a contract. It's between parties. I can't have a contract with myself. Just doesn't happen. For value, we're involved in some kind of economic exchange, and it has to be legally enforceable. You can see that this really is a sentence, but we need to add that is legally enforceable. That'd probably make it better. Slide anywhere. So we have a contract is an agreement between parties for value that is legally enforceable. The standard that courts are going to apply in deciding whether something is a contract or something else or nothing at all is going to be an objective standard. If this isn't your first paralegal course, you've probably heard your instructor talk about objective versus subjective like 50 million times. And so I'm going to do it one more time, so it's going to be 50 million and 1 times. And actually over the course of this semester, I'll probably have this exact same conversation at least 10 more times. So I apologize in advance. It's just a really, really important concept in the law, and it's one that students sometimes struggle with. And so I'm hoping that this will be the semester that it clicks for you, if it hasn't already clicked it, and that the light bulb will go off and you won't have to struggle with this concept going forward. So really we're comparing 2 universes, an objective universe and a subjective universe. When I describe an objective universe, I'm going to talk about things like Bob was 6'3". That's an objective measurement. A subjective measurement would be to say Bob is tall, because I'm making a subjective evaluation. I'm saying that he is taller than some people, but he's also shorter than other people. Bob would be relatively short for a professional basketball team at 6'3", but he's relatively tall for the general population. And so it all depends upon your point of reference. In certain situations, Bob is short. In some certain situations, he's typical. Some certain situations, he's tall. But when we talk about measurements like inches and feet, we're using an objective standard. That doesn't vary depending upon your point of reference. Bob is always going to be 6'3", whether he's playing in the NBA or he's an accountant somewhere. Our perception of his height in comparison to others is going to vary. So the objective standard is the 6'3". Subjective standard is tall. In the law, we almost always use the objective standard. I'm not going to say we never use subjective standard, but I'd say probably 95% or more of the time we use an objective standard. There's lots of reasons for that. One of the big ones is that a subjective standard is just darn hard to apply, to be honest with you. We don't really want to give people that much flexibility, either the judges or the jury that much flexibility, because then our law doesn't become predictable. You may recall when we were talking in chapter 1, we talked about one of the awesome things about the common law is that it is predictable. Not 100% predictable, but pretty predictable. One of the services that we as legal professionals perform for our clients is telling our clients, you're likely to win, or you're likely to lose, or this is likely to be what the court's going to say. If we didn't have predictability, we wouldn't be able to predict. We wouldn't be able to tell our clients what's likely to happen. And so they would be in a world of indecision. Indecision is very expensive. And so we don't want to be in that world. We want there to be predictability. And one of the ways we get there is by having objective standards. The judge isn't sitting back there thinking, well, gosh, I really like the plaintiff, and even though I think the plaintiff ran the red light, I just really like the plaintiff, so I'm going to give the plaintiff money despite the fact that he probably is the one who caused the accident. That would be a subjective standard. Instead, what the court should do, and usually what the courts do is apply an objective standard. They don't say, well, gosh, my personal feeling is, my emotional reaction to this is X or Y or Z. Instead, we expect, and courts usually deliver this, it is that they will be objective. They will step out of their own personal quirks, their own personal preferences, their own life experiences, although that certainly does inform their objectivity, but we're looking for objective facts, just the facts, ma'am, that type of analysis. So that's what we're mainly going to apply in contracts, and that's mainly what we're going to apply in the law. So if you are ask a test question in virtually any paralegal course, and it says, do we apply an objective standard or a subjective standard? You can almost be certain that, except in very few cases, the correct answer is going to be objective. If you struggle with this, if you want more examples, please come see me. This can be a tricky idea to get solidly set in your brain, and it is an important one. So I'd be glad to tease out some more situations that might be helpful. So this is our elements. These are our elements. Let me go back here. So this is our definition. And this is, we'll call this the elements. Actually, I don't have that on the slide. This is set up as if we go from 1 to 2 to 3 to 4 to 5. And there's some of that, but you could also just see this as a list. So don't get too focused on the arrows. The first item on our list, the first element, is going to be offer. But I want to pause right there and say it's really not an element of a contract. So I'm kind of lying to you here. This is an element of something else that is an element of contracts, because all of this is an agreement. These are the parts we need for an agreement. An agreement is an element of contract. Now, in a sense, does it really matter whether we say an offer is an element of a contract, or we say an offer is an element of agreement and agreement is an element of a contract? I mean, in a way, it doesn't make any difference at all. The reason that I highlight it is that there will be test questions where I'll say list the 4 elements of contract law. And they are agreement, this is number 1. They are consideration, which is number 2. They are capacity, which is number 3. And they are legality, which is number 4. But what I so often get is I will get a student who say it's offer, and it's acceptance, and it's consideration, and it's capacity. Or maybe I'll get offer, acceptance, agreement, and consideration. Well, the problem is if you include these 2 or even these 3 as elements of the contract instead of elements of the agreement, you're not going to cover all of these. So I don't mind you listing offer, acceptance, and mutual assent as elements of the contracting process. The only thing is that instead of needing 4, you're going to need, what, 1, 2, 3, 4, 5, 6, and probably 7, because I'm probably going to want to hear you say agreement too. So it's just super easy to just remember agreement. It's going to save you a lot of extra writing. So don't feel like you can't say offer. Just remember, if you say offer, you haven't checked off one of the four, because offer isn't an element of contract. It is an element of agreement, and agreement is an element of contract. So our first element is agreement, and look how neatly that tracks with this. So this is also an element. It's part of our definition, and it's an element. Our next element is consideration. Oops. And that exists right here. This is consideration. This is an element. We'll talk more about this in a second. And we have capacity. Now, capacity is not directly reflected here. It's kind of lurking in this topic. We'll talk about what capacity is in a little bit. But look here, when we get to legality or legal object, it sure is right here. So 3 of our 4 elements are present in our definition. So we'll talk about what all of these 4 elements are and what the 3 sub-elements of agreement are. And we'll also talk about writing. You'll notice something interesting about writing, though, because we have the word sometimes here. Now, sometimes when I bake sugar cookies, I add vanilla. In fact, I would say almost all the time. But if I'm out of vanilla, I can still make sugar cookies. And they are still sugar cookies. They may not be as tasty as if I had put vanilla in them, but a vanilla-less sugar cookie is still a sugar cookie. But if I try to make a sugar cookie with no sugar, it's not a sugar cookie. It may be tasty. Maybe I use maple syrup instead. But you know what? You have to have sugar in a sugar cookie in order for it to be a sugar cookie. So, because a writing is not always required, it isn't an element. It's an optional thing. It's like vanilla in the sugar cookies. So we don't say there are 5 elements, we say there are 4 elements, but we do flag this and say sometimes this is a requirement. And we'll talk about, gosh, we've got a whole chapter on that. We'll talk about that in lots and lots of detail going forward. So let's approach some jargon. And again, we see these terms in red. These are definitional terms, so they're important for you to flag and practice. And I hope that you are using your Quizlet every, 2 or 3 days, or whatever your pattern is, on a regular basis. Don't let a week pass without you having practiced some of these vocabulary terms, because you'll find it's a lot easier, a lot less dreadful to learn 2 or 3 or 4 than to learn 30 or 40 or 50. Not only easier and less unpleasant, but it's actually going to work a lot better, and you're going to spend a lot less time. So my philosophy is work smarter, not longer. And with those words in mind, learning vocabulary in little bits is a lot more efficient. That's the way our brains are designed to work. And so if your brain is like the typical brain, you're going to find that this is the path that's going to lead to more success. Okay. So we have a term, legalese. We use this term from time to time. Legalese is just a term for legal jargon. A lot of times when people say legalese, they have a negative meaning to it, like, oh, it's incomprehensible, it's very dense, it's poorly worded. That's the connotation, I guess, of the word, the feeling people have with the word. Even legal professionals have that feeling about it. But the denotation, the definition of it, is just legal jargon. And all legal professionals from time to time use legal jargon. It would be silly for us not to. I mean, it would be like if a doctor were talking to one of his colleagues or her colleagues, and were to say, instead of saying the carotid artery, he or she kept on saying, that thing that carries blood from that part of the body. No, that would be silly. If you're talking to somebody and they know what the carotid artery is, and you know what the carotid artery is, it's just a lot quicker to use the shorthand of this particular term. And that's the same thing in the law. We have terms that make life a lot easier to make sense of. And when both the speaker and the listener knows those terms, why not go ahead and use them? Yes, they're legalese. Yes, they're legal jargon, but that can be a quicker way of communicating. What you want to be careful about when you're using legal jargon is to make sure that the person who is going to be hearing or reading the word is familiar with the term. We all have different types of vocabulary. We have our everyday, easy peasy vocabulary that we use. Then we have the vocabulary that we might use when we're reading. And then there might be vocabulary when we're reading a murder mystery novel, and there's vocabulary when we're reading a textbook. And so when we're reading more sophisticated works, we expand and use that more sophisticated vocabulary. But the fact is that all of us have, because we have these different vocabularies, there are certain words that we just click on easier. Let me give you an example of this. If I were to say, to write this word up here, you know it. You know it's something that isn't big, that is petite, that is little. You don't even have to pause for a second to have complete understanding of that term. It's automatic. Let me write up another word. When we see this word, the everyday meaning, the meaning that we confront commonly, is the meaning that is 60 seconds. So when I see this word, my first thought is, oh, somebody's talking about 1/60th of an hour or 60 seconds. They're talking about a minute. But we also have another word in our vocabulary, which is minute. It's spelled exactly the same way. It's pronounced differently, but it has a very different meaning. And this means really small. Now, we all know both meanings, but the first meaning is in our everyday vocabulary. It's automatic. It's our go-to meaning. When we're reading, or when we're reading a note from that someone sent us a text about, and we see this word, we assume they mean 60 seconds. I'll see you in a minute. We don't think that they mean I'll see you in a minute. But when we're reading a textbook, we're probably more open to this meaning. Of course, we're looking for context clues, but we're more open because we're using our more expanded vocabulary. So we all have different vocabularies. As a general rule in legal writing, we want to stay into the plain English, the easy peasy vocabulary, and avoid words like minute. Now, sometimes we're still going to use them. We have to, just like carotid artery or something like that. But we want to, as much as possible, use words that people are going to instantaneously remember that term. So there's nothing wrong with minute. I don't want to discourage you from using it. It's a perfectly good word, but it's not one that we'd want to use as commonly as we would small or little or even petite. So legalese is fine, but try to avoid it. Try to use the simple, everyday, common English word instead, when possible. We also have two other terms we're going to talk about, and these are the terms promisor and promisee. We'll talk about these terms quite a bit as the semester goes forward, but right now what I want to focus on is not so much these terms, but the suffixes. And I'm sure as you recall from middle school grammar, a suffix is the part of a word that comes at the end. It's something that is attached to the word. And you can see that these two words, one has a suffix OR and one has a suffix EE. And so when we see OR ending in a legal word, it means basically the same thing as the ER ending in everyday English. So when you see the word inviter, that's the person who is making the invitation or making the invite. When we see the word writer, we know that is the person who is making or creating the right or the written document. And that's the same pattern we see when we're not working with the ER ending, but the OR ending. The OR ending is more common in legal writing. So the promisor is the person who's making the promise. The promisee is the person who receives the base word. Just like an invitee is the person who receives the invite or the invitation. So the invitee receives the invite. Now, we don't use the term writee in English. That sounds kind of goofy. But if we did use it, and I'm not suggesting you should, but if you did, it would obviously mean the person who receives the writing. So that would be, for example, the reader. Promisee, this suffix ee is very common, and it means the person who is receiving the promise. So we'll see this pattern with or and ee lots and lots of times in this course, and if you can keep this pattern in mind, and the example I recommend is inviter, invitee, because that is a case where common everyday English follows the same pattern, then you will be well set up to be able to quickly identify those words. So in this case, a promisor is someone who makes a promise. Now, in everyday conversation, we'd probably say the promiser with an ER. That's the everyday English, but now we're talking in the legal environment, so we use the OR ending, but it means the same thing. Okay, so we have an offer. That is going to be, as you recall, the first element of our contract. So what is an offer? And again, we can see this is in red. This is a definition from the textbook. It's a proposal made with the purpose of obtaining an acceptance, thereby creating a contract. So we make an offer in the hopes that someone will accept the offer. And the person who makes the offer, we can see it ends with OR, it's the person who's making this offer, who's creating the offer. The offeree is the person who is receiving the offer. At this point, the offeree might choose to accept it or might choose to decline the offer. The person who's in the offeree situation hasn't done anything. He is kind of in a position to possibly make choices or have things happen. He is kind of we don't know what's going to happen with him. We just know that he's in a position to make some choices. So the offeree might ultimately accept or might decline. So here we have our first item checked off. We have an offer. That is one of our requirements for the contracting process. Again, we have all of these under the umbrella of agreement. So now we have an acceptance. Obviously, you can't have a contract unless you have both parties agree to the contract. That was one of our requirements in our definition, right? Going back here. An agreement between the parties. So that requires, obviously, both parties to agree to it. And so we need an offer and we need an acceptance before we have that agreement. So the acceptance is the assent by the person to whom the offer is made. And who is this person? We just found out who that person was. It's the offeree. So assent by the offeree. So let's say that we have three people. We'll have Bob here, and we'll have Larry, and we'll have Anne. And Bob says to Larry, "Hey, Larry, I'm willing to sell you my pencil here. I'm willing to sell it to you for 10 cents, Larry. Would you be willing to buy my pencil for 10 cents? Larry looks at the pencil. He's kind of thinking about it, and Anne chimes in at that moment. Bob, yes, I will buy your pencil for 10 cents. Is that an acceptance? Well, it is an assent. Anne has said that she will agree to the terms that Bob offered. But Anne is not the offeree. Let's go back and look and see what the offeree has to have going on. The offeree has to be the person to whom the offer is made. But Bob specifically made the offer to Larry. So Larry is the only person who can accept Bob's offer. So when Anne says, yes, Bob, I will buy your pencil for 10 cents, that isn't an acceptance. We still have the offer. We're waiting to hear what Larry will do. Larry is the only person who has the power to accept Bob's offer. Obviously, if Larry chooses not to accept, we don't have an acceptance, we don't have an agreement, we don't have a contract. So we have a requirement of an offer and acceptance as part of our agreement, our first element of contract. We also have a third element for an agreement, and that is mutual assent. How you choose to describe mutual assent or position mutual assent is really kind of something that legal scholars differ on. There's a couple of different views of this. This is the one that I happen to use, and so this is how I will be presenting in this course. It's a little bit different than the way the textbook does it. I like our textbook. I think it's a good one, but this is one area that I'm not as fond of. And you can see what I've done here is I've taken the definition from the textbook, but I have shown how we need an offer plus an acceptance plus mutual assent for an agreement. So these are all elements or ingredients of agreement. And we already know that an agreement is an element for a contract. We've already talked about what an offer is and what an acceptance is. And you may be thinking, well, what else do you need for an agreement? Well, most of the time, you're done. You've got everything that you need. Most of the time, if you have an offer and acceptance, this is pretty much automatically satisfied. This is where you have a meeting of the minds, consent, agreement. Well, if Bob makes an offer to Larry, hey, Larry, you want to buy this pencil for 10 cents? And Larry says, well, yes, I do. I do want to buy that pencil for 10 cents. We have an offer and we have an acceptance. It seems like the two have a meeting of the minds, and so it looks like we have an agreement. It looks like we've satisfied the first requirement of contract law. But let's imagine that this conversation was happening in Buffalo, New York. And it just so happens that Bob is a Canadian and Larry is a United States citizen. And so Bob was thinking that when he said 10 cents, he meant 1/10 of a Canadian dollar. And when Larry said 10 cents, he meant 1/10 of an American dollar. So it sounded like they had an offer that was accepted, but what Larry was accepting wasn't the offer that Bob was making. It sounded like it was. Maybe both Larry and Bob thought it was. Maybe Larry thought Bob was a U.S. citizen and Bob thought Larry was a Canadian citizen. They didn't realize that they were talking at each other instead of to each other. But because they had that fundamental misunderstanding, while they had an offer and they had an acceptance, they didn't have that meeting in the minds. They didn't mean the same thing with those words. When this is absent, they don't have a true agreement. Without an agreement, they can't have a contract. So this is a necessary element to the agreement. It's rare that this isn't satisfied. We'll have a chapter where we'll talk about 6 circumstances where there can be a problem with it, but certainly the vast, vast majority of times, if you've got this and this, you're going to have this as well. So this is how we're dividing up, or this is again, the way I like to look at it. This is our first element of a contract. Here is our second element. Here's our third element, and here's our fourth element. So sometimes people get a little bit confused with mutual assent. They think, well, gosh, I need an offer, I need an acceptance, and now I need a third thing. No, you don't need a third thing. The acceptance has to be genuine. It has to be accepting the offer. Even if the words match, there may not be that meaning. Again, going back to Canadian dollar versus American dollar. So this isn't a third thing that has to happen. It's just pointing to the possibility of there being miscommunication here. Okay. And we'll talk at length about this in more detail. I realize that it's a little bit difficult to have a firm idea what I'm talking about until we go through lots of examples, but hopefully it'll make more sense at that time. Okay, so now we're going to talk about the second element. We've really finished our initial discussion about agreement. Let's talk about consideration. And here is our definition. And I'm going to tell you from the very beginning, this definition of consideration is pretty awful. But there's no better definition. I wish I had some magic pixie dust I could spread out on this, and it would make this make a lot more sense. The problem is that this is such a basic concept in the law. It's a little bit like looking or trying to find the definition of the word red in the dictionary. If you were to look up the word red in the dictionary, let's say you were an English learner and you're reading a book and you see the word red and you're like, gosh, I don't remember what that means in English. And so you go to a dictionary. Guess what? Whatever that dictionary entry, however it defines red, it's going to use bigger words, more difficult to understand words than the word red. Red's such a basic idea in English, and I guess in really probably in every language, that to define it, you're going to have to use bigger words. Similarly, defining the word is. The definition, there's going to be one in the dictionary, but if you need a dictionary to tell you what the word is means, whatever that dictionary entry is not going to help you. Same way with consideration. Such a basic concept that a definition just doesn't really work it out, but we've got to have one. So here's our definition. That which is given in exchange for performance or the promise to perform. The price bargained and paid, the inducement. The way I like to think about it is this is what I'm giving to make the deal happen, and I'm getting to motivate me to make the deal. Going back to Bob and Larry. Bob is going to provide a pencil. That's his consideration. That's what he's giving up. Larry is providing the 10 cents. Maybe it's American 10 cents, maybe it's Canadian 10 cents. It's hard to draw with this. Here we go, 10 cents. That's Larry's consideration. Bob's not going to give Larry the pencil unless Larry gives the 10 cents. Larry's not going to give Bob the 10 cents unless Bob gives Larry the pencil. These are the two ingredients that are necessary for this particular deal. This is an essential element. Let's say Bob were to say to Larry, Larry, I've got this extra pencil. I don't need it. You want to have it? And Larry says, sure, yeah, thanks. And Bob gives Larry the pencil and Larry takes it. Was that a contract? No. Bob has given Larry a gift, a perfectly valid thing to do. And once Bob gives it to Larry, he has now given his title or his ownership interest in the pencil to Larry, and now it is Larry's pencil. So there has been a change in legal relationships, but we don't call it a contract because Larry didn't do anything. For us to have a contract, we need to have Larry doing something or giving something and Bob doing something or giving something. That's what we call consideration. Again, we have a whole chapter on that. So we've talked about agreement, which is our first element. And now we've talked about consideration, which is our second element. And we're going to move on to capacity, legal capacity. There's two definitions that the textbook has advanced. One is competency in the law. But you know what? If you don't know the word capacity, you probably don't know the word competency, right? So it's a bit of a circular definition. I like the second definition better. A person's ability to understand the nature and effect of an action in which he is engaged, also known as legal capacity. We can see here we have three examples of people who lack legal capacity. We have this a little baby smiling on her face or his face and flipping through some boring document. This kid can't read, obviously, and even if he could read, this is going to have words that he or she doesn't know at all. It would be nonsense to him or her. He or she doesn't understand what this document is. If this were a contract, he or she would not understand it. This gentleman here is unconscious. He's had a few too many to drink. Even if he were somehow or another still conscious but just really, really drunk, he wouldn't be able to make good decisions or really understand the nature of entering into a contract. We would say that he, just like the baby, lacks capacity. And here we have somebody who appears to be mentally not well. Maybe he's delusional, maybe he's had some psychotic break, he's living in his own reality. he doesn't live in the world that we live in, and so therefore we would say that he lacks the ability to contract. Of course, not everybody who's had a little bit of alcohol or drugs is incapacitated, and not everyone who experiences a mental illness is incapacitated. It requires a pretty significant impairment level before we say somebody lacks capacity or is incompetent. Now, we do say everyone under the age of 18 is incompetent. So we could have somebody who's 17 who's very sophisticated, might very easily be able to understand this document, but we just have an on-off switch for those folks. These categories, once a person hits 18, we have a very strong presumption in law that they are competent until a court has determined that they are not. So that is capacity. In order to have a valid contract, both parties to the contract have to have capacity. So we have now talked about the third element. So we have agreement, which is our first element, consideration, which is our second element, capacity, which is our third element. And now we're going on to our fourth element, our final element, which is legality. The condition of conformity with the law, lawfulness. More commonly than saying legalities, I will probably say legal object. Either term is fine. The contract has to have a legal basis. So a contract for prostitution is not a valid contract unless, of course, it were in a jurisdiction that permitted prostitution. For example, certain places in Nevada has made prostitution lawful. An illegal drug transaction is not enforceable. But in places where you can buy marijuana lawfully, assuming that the parties are following whatever the legal requirements are, then that would be a legal contract. Gambling in most places is unlawful. If you're in Vegas, yes, you can gamble, and those contracts would be lawful. But if you try to have a roulette wheel or a poker business in Texas, guess what? That contract would not be lawful because it is not for a legal purpose, a purpose that is permitted under Texas law. There's lots of other, obviously, illegal contracts. These are just kind of introducing you to the concept. A contract has to be for a legal purpose in order for it to be enforceable. So now we've gone through all four of our elements: agreement, which is our first element, consideration, our second element, legal capacity, our third element, and legal object, our fourth element. Now we're going to get to our sometimes one. Sometimes we need to have a fifth requirement in order to have a valid contract. It's not always required, so we don't consider it an element generally. And that has to do with writings. Mainly, the main place that we look to see whether we need to have a writing is a document called the Statute of Frauds. What a strange name for a statute that has to do with whether you need a writing or not. It is strange. There will likely be one or more students in this class who will answer a test question on the final examination wrong. And I'm going to tell you basically what the question is going to be, so you won't be that person. The question will be something like this. What is the Statute of Frauds about? And there will be people who will say, well, it's about fraud. You know, somebody tricks somebody into entering into a contract. That's fraud. And the statute of fraud prohibits that and talks about the penalties that'll happen. A perfectly valid guess about what the statute of frauds is. I mean, that's what most of us would guess probably if we had not taken contracts. But that isn't at all what it is. This is a poorly named statute. There are reasons why it's called statute of frauds, but a much better name for it would be statute of writing. So write your state legislator and recommend that we make a change in this. He's going to ignore you or she's going to ignore you, but that would be a much better name in my opinion. Because what the statute of frauds does, it explains when contracts have to be in writing. There was an expression that I grew up hearing, which is an oral contract isn't worth the paper it's not written on. And the implication from that statement is oral contracts aren't enforceable. That is completely false. The vast majority of oral contracts are completely enforceable. They're not a good idea, Because when you have an oral agreement, people can lie, people can forget, people can get confused. People a lot of times don't get down to the nitty-gritty details, so there's a lot of ambiguity in it. So there's a lot of problems with oral contracts. But the problem with an oral contract is usually not that it's unenforceable. It's just its provability that becomes problematic. But again, there are some times where you need to have a writing. And so an oral contract in those situations isn't enforceable. But generally speaking, oral contracts are enforceable. So this is our definition for statute of frauds. A statute existing in one or another form in every state that requires certain classes of contracts to be in writing and signed by the parties. Its purpose is to prevent fraud or to reduce the opportunities for fraud. So there is some connection with fraud in the name, and we'll talk when we get to this chapter. We'll talk in more detail about why it has that name and what its story is. It's kind of an interesting topic. I'm not going to go into great detail today. I don't want to overwhelm you with information that you don't need today. But just keep in mind, it's not statute of frauds really, it's statute of writing. If you can make that mental switch, you will be in good shape. Whenever you see this, think writing instead. You'll see I mentioned the UCC up here. A little refresher, the UCC of course stands for the Uniform Commercial Code. This is also a statute. It's also a state law statute that has to do with contracts for the sale of goods. The statute of fraud deals with common law contracts. The UCC, of course, deals with contracts that are covered by the UCC. The UCC is its own equivalent of the statute of frauds. So in this course, I'll talk about the statute of frauds, but what I really mean is the statute of frauds plus the UCC part of the statute of frauds. That'll make more sense when we get to that chapter, so don't worry about the ins and outs of that at this time. This is kind of a neat thing. A lot of times in the business world, we think about, your handshake. The implication is you can trust me. You have my handshake on it. I'm not going to back out of it. The statute of frauds says, well, a handshake isn't enough when you have to have a writing. The vast majority of the time, it's perfectly fine. A handshake, again, you might have some evidentiary problems. People might lie. But if everybody agrees that something was said, then that contract is binding. But then there are these 6 situations, really, where, no, the handshake just isn't enough. It's good. It's a good starting point. You're going to have to orally work out the details and then put it into writing. So now we've gone through our whole picture. Let's just review one more time. We have our agreement, which is our first element. The agreement has 3 sub-elements: offer, acceptance, and mutual assent. We have to have all 3 in order to have an agreement. If we have an offer and acceptance but no mutual assent, do we have an agreement? No, we don't. If we have offer but no acceptance, do we have an agreement? No, we don't. We need to have all 3 in order to have an agreement. If we're missing any of these, we don't have an agreement. And if we're missing an agreement, we can't have a contract. Our second element is consideration. It's an element, so if we're missing this, even if we have an agreement, we're not okay. We have to have this in order to have a contract. It's an element. We also have to have legal capacity. In fact, just like both parties have to provide consideration, both parties have to have legal capacity. If only one party has legal capacity and we have consideration and we have an agreement, we still don't have a contract, because this is a requirement that both parties have capacity. And finally, the contract has a legal object. If we have capacity in both parties, if we have consideration from both parties, if we have an agreement but we don't have a legal object, we don't have a contract. And finally, sometimes if we have a contract over one of the subject matters that requires a writing, we would have the 5th requirement: do we have a writing that is legally sufficient? So we are now done with our first portion of Chapter 2, talking about kind of an overview of the elements of contracts. each one of these topics has its own chapter going forward. Well, I think maybe offer and acceptance might be in one chapter, but the rest of it will have these items in their own chapter. So we'll go into a lot more detail. As always, if you have questions about this material, please reach out to me, send me an email, come by my office hours so we can explore these in more details. That's especially important if this is your first semester in the program. I want to be additional support for you in that circumstance. We can get you to the same knowledge level, to the same level of success as students who aren't in their first semester, but it is going to take a little bit more work. So just let me know how I can help you get to that place, because I want you to be as successful as everyone else in the program. Thank you for your attention, and I hope you have a great day.